We're very lucky to have with us live in the studios this morning Peter Holmes. Peter Holmes is running for the position of the Seattle City Attorney, and we'll be talking about his views and his campaign. Start out and tell us, why are you running for Seattle City Attorney?
It's as simple as wanting to feed a desire to serve the public interest with my legal training and skills. It's one that I began in early 2002. I left my law partnership in late 2001, and City Council appointed me in early 2002 to the city's first civilian oversight board for the Seattle Police Department. I finished that tour of duty at the end of last year and knew that the work wasn't done, and the city attorney's office seems to be the right spot, the right match, and the place that I can probably bring my skills to best serve the city of Seattle.
Well, that was a pretty tough job being with the OPA. Is that something that you had desired to land at the time?
It's one of those things that watch what you wish for. I did not leave my law firm planning to go into police oversight. In fact, I had thought that a year or so off from law practice in order to decide where to direct my career would be appropriate. But merely a few months after leaving the partnership, the OPA Review Board came into existence, and City Council began asking for nominations for the very first three-member panel. My name was put forward in early 2002, and I was selected from, I understand, 75 or 80 candidates, and we were all appointed in April of 2002.
And were you surprised by what you found when you joined the OPA?
Yes, I'd say first excited, because I've been a career lawyer I've been a lawyer. I'm in my 25th year now, in fact, and it has been a very rewarding and challenging civil practice, civil litigation and bankruptcy and insolvency work. And so the opportunity to get involved in a completely new aspect of the law, that is criminal law, was an amazing challenge and something that was very exciting to me. I hadn't considered criminal law really since my first year in law school, and suddenly I had a baptism by fire. I jumped into the position doing, for instance, ride-alongs and roll calls, every precinct, every watch. I took every training opportunity that the police department gave us. I graduated a year after the appointment from the Community Police Academy. I attended the same courses that recruits take in the State Justice Academy. So it was a fascinating process, and I learned a lot about the criminal law and procedure from beginning to end.
And while you were on the OPA, the OPA came out with multiple reports. I can't remember if it was every year or.
The central mission was 2 reports a year. Okay. Correct. Yeah, that was the main mission, and it was a broad responsibility to report to the mayor, the city council, and the people of Seattle how the misconduct system in Seattle was working. A brand new system, I might add.
And what's your summary of how it was working over that time period?
My ultimate conclusion, looking back on 6.5 years of service, is that we have an excellent police force. And as you would expect with any large urban police force, one that certainly has problems. And that's why we have accountability systems, is to make sure that we're dealing with those responsibly. The resistance that was anticipated, not necessarily by me, but by people that advised us as we were trying to put together the very first board. We had no precedent. We were the very first OPA or first civilian board in Seattle. We were warned that community groups would have distrust. Are you really going to be effective? Are you really going to be trying to get at the truth? The rank and file, we were told, would also distrust us. What the heck does a civilian know about the tough work that the police officers have to do? And so I found that those questions were answered at either end of the spectrum by simply showing your commitment and rolling up your sleeves and going to work. I tried to demonstrate to the rank and file that I was willing to go and walk with them on full 8-hour shifts, spend time trying hard to understand the work that they did. At the same time, we went to dozens of community groups, police forums, and the like. Every interest group that had some concern or interest in the workings of the police department, we were there, we were talking to people. And I found that went a long way toward showing people that we were committed to doing the job, calling it like we see it.
And what point, what folks within the city did you get resistance from on any of your work?
Well, initially, there was resistance, I think, from the mayor's office. And that was kind of surprising to us because, among other things, we had also reached out to the mayor's office and said, would you like to meet with us? Now, we would meet with a senior policy advisor from the mayor's office, but, trying to talk to the mayor himself was always, you're a creature of city council, and this is the mayor's office, and we need to draw a line. And our response, of course, was, no, police accountability is everyone's responsibility in city government. This is, public safety is the largest portion of the city budget, or the largest single item in the city budget. And, of course, the way the police department operates affects all of us in our daily lives. And so we reached out as best we could and had a hard time trying to connect there just to see if we could coordinate our roles, and that proved to be ultimately an unnecessary hindrance. I mean, in the end, of course, we produced reports that called it like we saw it, that pointed out the good and the bad, and it was a hard fought battle in a lot of ways toward the end, especially, but in the end, you may be aware we were successful in getting 29 changes after 6 years on the board implemented in the way the department handles its police misconducts.
And what of those reports? Did those all get out to the public?
The last two were interesting. And this goes back to your first question about why I'm running for a city attorney. One of the problems that we had was how to cope with our obligation, one that we readily accepted, to maintain confidentiality for the police officers. And every member that's ever served on the board has fully embraced that. There is absolutely no reason that individual officer identities have to be disclosed. And certainly it's not the board's responsibility to recommend discipline, and we never did either of those in any case. And yet, because the reports were at times less than glowing, we found resistance, and in the form of our confidentiality agreements. They were unusual in that they were mutual indemnification clauses. That's lawyer talk for simply saying that we will indemnify you, we the city will indemnify you, provided you don't disclose confidential information. If you do, you not only lose your protection, but you have to indemnify the city if the city is sued. And so that's a pretty, onerous burden for private citizens to bear. The problem with it was that the definition of confidential information was so broad that, according to the city attorney's office, all 3 or 4 of our last reports arguably violated the confidentiality agreement. So we released one in 2004 that without any assurances from the city attorney's office, and we were not sued, fortunately. But the subsequent reports, we ran into this same problem. The city attorney's office said, we can't tell you that you'll be indemnified. We can't give you the assurance you need. In 2007, a report was rather infamously released, was leaked to the Times. That created quite a maelstrom in the headlines, which in our mind was quite unfortunate, because it's not the way we wanted to handle that case. In fact, to this day, we're not certain where that leak occurred, but it did not happen at the board. Nonetheless, after the smoke had settled, that's when the mayor appointed his blue ribbon panel, city council appointed a panel as well, and they ultimately vindicated the board's report, the board's work. The better course for us would have been that that report had been released in the normal course, which would have had it going to the chief of police first, opportunity to meet with him, and then a coordinated release, rather than the hysteria that followed the sensational leak. Now, our last report was never completely released. That was a report just last year. And we, again, ran it by the city attorney's office, and the city attorney found that 6 or 7 pages of that report was objectionable, even though, once again, it did not name any officers, did not recommend any discipline. Ultimately, and with the advice of city council, the advice of the city attorney, the city council president released a sanitized or a redacted version of that report, but we never released the full report.
So it would be found, segments of that report, the 6 or 7 pages, were found objectionable by whom?
By the city attorney's office.
Okay.
I don't think that I should name an individual officer, but
sure.
But there was a lawyer within the city attorney's office, not Tom Carr, who was assigned responsibility for that.
And then they would feel that there's individual police officers that would have a problem with that, or the guild, or what?
Both perhaps. I mean, the problem was, and we acknowledged it, of course, was that the cases discussed in there did involve some rather notorious cases. In other words, it wouldn't be hard, and we acknowledge this, for people reading the report to know who you were talking about. But that's an interesting point, because one of the panels that was appointed, the City Council panel on police accountability, pointed out the problem that the way our setup is now in Seattle, with the burden of these confidentiality agreements, you could have a representative such as the chief of police, speaking hypothetically, make an inaccurate statement in public identifying an officer. And if the review board were to attempt to correct the inaccurate mistake, the board would be held liable for attempting to tell the truth, while as the chief would escape liability for having done otherwise. That's almost a direct quote from a part of the report that was written by a law professor from the University of Washington.
All right, so if you were the Seattle city attorney, would you handle all that differently, the reports going out to the public?
I certainly would. It is quite important that, in our state constitution, the right of privacy, of course, must be honored. And I believe that the public's right to know can be honored while protecting individual privacy right. That's one of the things that our board stood for all the way through our tenure. But when there's doubt, the public's right to know must be ensured. One of the reasons that I'm running, my wife gave me permission to run on the day that President Obama was inaugurated. One of the things that he said that was so moving and pertinent to my experience in government was that it's time that we hold our leaders accountable and insist that they conduct their business in the light of day. And that will be my personal creed in the city attorney's office.
So beyond just these reports, what do you see as making the city and your office more transparent?
Well, certainly I think we need to hold the city attorney's office more transparent. One example of an operation that I think shows why we need change at the top in the city attorney's office, a lot of your listeners may be aware of the program Operation Sobering Thought that was conducted over a year ago, a crackdown on nightclubs in the city. Despite this recession and despite our efforts to promote Seattle as the city of music, there was, I believe, a misguided attempt to crack down on some of the problems that attend nightlife in the communities where they're located. The police department conducted a sting operation, which was apparently very well executed, and it resulted in a crackdown at 15 clubs, I believe, dozens of arrests. And yet, at the end of that operation, every single arrested individual, all of the charges were dismissed. There were no plea bargains, and the entire operation was essentially a zero. You could go to the police department, this is on your transparency issue, and ask them what did that operation cost, and they can tell you to the dollar what that operation cost. I think the police department did a great job of tracking its operations and responding to public disclosure requests. You ask the city attorney's office, and they cannot tell you even what lawyers were assigned to the prosecutions. So I think one of the first things I would do is to make sure that my office is accountable and responds and to disclosure requests, and certainly in its annual reports gives true reports, a true accounting for what it has accomplished, as well as its failures over the prior year.
I think Tom Carr's response on that was something to the effect of, well, we haven't fielded any court cases or any fines for, not being forthcoming with information. What's your response to that?
Well, there have been, I believe, I don't know what time period, but I think there was some $80-some thousand in fines actually that have been assessed against the city for failure to produce documents. Now, this is in connection with public disclosure requests. I thought you may have been going another angle too. The city attorney's office, deals not only with misdemeanor crimes committed in the city, but also it's the chief legal officer for the city in terms of providing advice to the other departments, as well as defending and initiating civil lawsuits. In fact, that portion of the litigation burden is greater than the criminal burden. And in that regard, we have seen, for instance, liability incurred by the city as a direct result of decisions made by the city attorney. One of the big differences that Tom and I have as far as our philosophy and theory is that I think it's significant that Seattle is unique in Washington and among a lot of major cities across the country that it elects its city attorney. In most municipalities, the city attorney, the top legal officer for the city, is appointed typically by the executive and confirmed by the legislative, the council. I believe that because Seattle purposefully decided to elect its city attorney, that it means that the voters are my clients, and that means that you're asking your city attorney to exercise independent judgment and legal reasoning and skills in the legal matters that come before you. Now, as a result of, and by contrast, Mr. Carr's position is that the city attorney defends the city. And consequently, that has led to results such as the mandatory car impound law. At the outset of his term in 2002, Seattle had a practice that was roundly criticized by human rights advocates and the like, where if you were driving with a suspended license and a Seattle police officer pulled you over, that officer had no discretion. Your car was impounded on the spot. I don't think you had to be a lawyer to suspect that might violate this constitutional principle we have that you can't be deprived of property without due process of law. And yet that law was enforced and continued by the city attorney's office, and even after the Washington Supreme Court said it was illegal. So it wasn't until a class action lawsuit had been filed against the city and where the city was exposed to a $1.3 million judgment that the practice was finally ended. That's the kind of judgment that I think the city attorney needs to exercise on behalf of the city, if not to make sure that we're not burdening our working poor and predominantly minority communities, as was the case with the impound law, then at least to make sure we're not incurring civil liability that's going to further deplete scarce tax resources.
Does the person coming in as city attorney, do they get to bring in any of their own staff members, or are they basically inheriting a staff?
Civil service rules will certainly apply about career lawyers and staff, but I fully intend to take a fresh look at this office. I think that the city attorney's office has immense potential to actually be a problem-solving entity for the city. Rather than litigate first, enforce first, incarcerate first, I think that we need to really examine its potential as a problem solver. I've heard people on the campaign trail come to me with their frustration. For instance, take an interagency dispute, a school district and a parks department property where there's disagreement about where the boundary line is. That boundary dispute, in turn, keeps any neighborhood development ideas completely in limbo because they can't move forward. They can't decide, a beautification project, for instance. The city attorney's role has typically been to be in there and simply not take sides and advise these two government entities how to avoid liability. Instead, I believe that the city attorney's office could be in there and say, look, guys, these three entities here, school district, Parks Department, and now city attorney's office, we're all paid by the same people. Our bosses are the voters. We need to work this out and show them that this government can function and move forward. And that's the kind of role I want to model in the city attorney's office. And if it takes reorganization of the department, I will do that.
In reading about some of your debates with, or your debate with Tom Carr, jails has come up. How does jails figure into the position of city attorney?
The city attorney, of course, is the main prosecutor for the city, and again deals with misdemeanor crimes, as opposed to the county prosecutor who will prosecute felonies in the King County Superior Court. City attorney goes to the municipal court. The jail issue arose really 8 years ago when we first learned that King County intended to take back the jail beds that it leases to the city of Seattle in the King County Jail. We've known this for 8 years, and yet 8 years later, we've painted ourselves into a corner in that we have no place, we continue to have demand for jail beds, and we have no place to put them. So that's why you hear discussions now that we may be forced to spend between $200 and $250 million for a brand new jail. I think that the city attorney should take as job number one, and it will be my responsibility if I'm elected, to do everything in my power to see that we don't have to build a new jail while we're closing neighborhood schools. For a country that already incarcerates more in absolute terms and relative terms, percentage of its population than any other nation on the planet, I think it's the wrong thing to do. And if there is a silver lining in this recession, we know we can't afford it as well. Now, how do you do that? You have to find alternatives to incarceration. That's after there's been arrest. We need to expand the community court system. We need to use the mental health court, not requiring defendants there to plead to a crime before they can actually participate in the court. And we need to make sure at the front end that we're diverting potential arrests from ever happening. I'd like to prevent crime. I'd like to be proactive. I'd like to spend more time on expanding programs like Clean Dreams that has been very successful in the Rainier Beach area near where I live. And so I think until you have really exhausted all avenues for reducing the need for jail beds, when King County leadership is resolved after this election, we need to go back to the King County leadership and show that we have truly reduced our jail population, our jail demand to as low as we possibly can, and then see if we can avoid building this new jail. But unless the city attorney says, this is going to be my job, I want as my goal to avoid the need to build a new jail, I think that we're going to be on a track, the same track that we seem to be on right now, and that is a jail will be an inevitable part of our future.
Your 8 years on the OPA, in addition to the disagreement over release of the reports, did you have any other direct dealings with Tom Carr? The transparency issues were the main issues that Tom and I disagreed on. It's my close work with City Council and with City Hall has shown me that there are so many other areas that we can do a much better job. Back on the issue of the jail, I think that we need to have a city attorney that is not afraid to say, for instance, that it's about time the state's largest city, the top legal officer in the state's top largest city, takes a stand on decriminalization once and for all. That, again, is a source of demand on jail beds, and it makes no sense. Last session of the legislature, there was a bill that would have converted possession of small amounts of marijuana from a misdemeanor punishable by time in jail to a simple civil infraction, no criminal record, $100 fine, and that bill was defeated. And it's well known that Mr. Carr is on record as adamantly opposed to decriminalization. I think that's a mistake. I think that, again, since we know that some 70% of Seattle voters
want that present crime to be decriminalized. It's a perfect example of why an elected city attorney, who also happens to believe that's a wise course, should take a stand and ask for legislation to decriminalize marijuana.
You stated that the Seattle City Attorney, since it's an elected position, that if you were elected, you would be really answerable and working for the citizens. So what mechanisms, if any, would you create to take input from citizens?
Well, I will certainly want to maintain an open door policy. We already have lots of formal institutions that are intended to bring in that citizen input. That was the precise purpose of the OPA Review Board. That's why it was very shocking to me that our mayor didn't want to hear from us. We did report through our written reports, but there's a lot more that could have been done effectively, I think, by having a kind of an open dialogue. And we're not talking an onerous meeting schedule. We're talking about let's get together once a month, that kind of thing. And so I will certainly make sure that all of our standing boards and commissions that I hear what their recommendations are. I will maintain an open door policy. And going into this office, I'm already, in fact, receiving lots of advice from a broad cross-section of the community, both prosecutors and defenders on the criminal side. I've talked to trial lawyers who have litigated against the city and have specific ideas about how the city can do a much better job. I've already described to you the example of citizen activists who have been trying to do beautification projects and how the city attorney's office has not been an advocate for them. Just last Saturday, I heard former council member Peter Steinberg describe when he was council president. He wanted the legislature to help enact legislation to bring a green building program into the city back in the late 90s. And the mayor's office, in the early 2000s, and the mayor's office did not want to be involved in that or didn't want to lend the building staff, the construction staff to that effort. And so when Mr. Steinberg went to the city attorney's office, the city attorney didn't want to get involved. Well, that's, I think, precisely if your policy arm, if your legislative body, the city council, wants your assistance to further a policy goal that they've identified, I think that's where the city attorney needs to be a resource, not an obstacle.
Well, I want to thank you very much for coming in and spending time with us this morning.
Thanks very much.